Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
Hey guys, how are y'all doing? Y'all come on in, have a seat. We're not going to overtalk it. We're not going to overdo it. We're going to get right on into it. Y'all already know about my copyright disclaimer. Y'all already know about my QR code, direct link to my X page. Now, let's get started. Now, if you haven't noticed by the title of this video, we are here to get into Megan Thee Stallion, or also known as Megan Pete, versus Milagro Cooper. Now, plaintiff's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renewed motion for judgment as a matter of law in incorporated memorandum of law. Let's get into it. Plaintiff Megan Pete, by and through her undersigned counsel and pursuant to Federal Rules of Civil Procedure 50B, 59E, and 60B, respectfully moves this court to reinstate the jury verdict as to plaintiff's defamation claim and to amend the final judgment consistent with the jury verdict, and in support state as follows. Okay, let's get into the introduction. This case should have been tried and was rightfully tried on the merits of plaintiff's defamation claim. At the pleading stage, the court properly decided a threshold and dispositive status issue that defendant is not a media defendant entitled to protection under section 770.01. See order on motion to dismiss. You can refer back to docket 36. That ruling, which was not challenged by defendant, governed subsequent proceedings. The parties proceeded through discovery and trial preparation in reliance on that ruling. Under the law of the case doctrine, that legal determination governed later stages of this case absent a recognized exception. Despite the fact that defendant never moved for reconsideration of that ruling, never moved for summary judgment on the basis that she was a media defendant entitled to pre-suit notice, never included this issue in the parties' joint pretrial stipulation, and you can refer back to docket 133. And never raised this issue at the October the 30th of 2025 pretrial conference. Defendant led the court astray at the November the 10th of 2025 final pretrial conference and during the trial, and re-injected the rejected media defendant status defense into the trial. The court ultimately allowed the inclusion of several special interrogatories in the verdict form concerning defendant status as a media defendant, including one specifically asking whether defendant was a media defendant. The jury returned a verdict for plaintiff on defamation, but answered the interrogatory asking whether defendant was a media defendant in the affirmative. The court then entered a final judgment that did not include the jury's verdict as to plaintiff's defamation claim because the jury's conclusion that defendant was a media defendant precluded judgment for plaintiff on the defamation per se claim. You can refer back to docket 227. This outcome impermissibly allowed defendant a second bite at the apple on a settled legal issue and should be corrected. This motion does not seek to relitigate matters already properly decided, nor to present new evidence. Instead, plaintiff asked the court to correct a legal error that directly affected the outcome of this case. The submission in use of an ultimate status question that the court had already decided as a matter of law. Relief under Rules 50B, 59E, and 60B is warranted to correct this error and prevent manifest injustice. All right, let's get into the background. Defendant exhibits nothing that a media defendant would. She, one, is not an objective, disinterested, or neutral reporter. Two, makes biased commentary intended to promote her business. Three, disclaims being a journalist and flouts its code of ethics as inapplicable to her. And four, disseminates false and defamatory messages that misinform the public. And then they get into it here. Okay. So defendant is neither neutral nor disinterested. She is a biased representative of Mr. Daystar Peterson. Defendant aligns with Mr. Peterson prior to his criminal trial. The evidence at trial and affirmed by the jury proves that defendant is not disinterested, is not a disinterested reporter. Rather, she is a paid surrogate of the Peterson, Sunstar and Daystar Peterson, hired to promote their false narrative that plaintiff lied about being violently shot and to further smear her reputation by branding her as an alcoholic and mentally R-word, among other attacks. Mere months after Mr. Daystar Peterson shot plaintiff, defendant wasted no time aligning herself with him. Okay. By aligning herself with the Petersons, defendant aided Mr. Peterson's circumvention of the protective and gag orders that prevented him from speaking to or about plaintiff in relation to the criminal case. Defendant willingly became Mr. Peterson's personal publicist and bullhorn, someone Mr. Peterson could rely on to publish his knowingly false and debunked narratives while maintaining a consistent line of attack against plaintiff. Defendant performed her services not as an impartial reporter or journalist seeking the truth, but as a paid surrogate compensated by her purported sources. And that's just case law from this case here. And if you're paying attention to the actual docket, then you will understand that up to a week ago, Megan's legal team, they did drop all of the exhibits. And so this is just the case law from all of those exhibits, but we're going to continue. You can pause your screen and read, but I'm going to continue, okay? Defendant proudly showcases her allegiance to Mr. Peterson during his criminal trial. Leading up to Mr. Peterson's criminal trial, defendant and Mr. Peterson's father coordinated a public relations campaign designed to obstruct justice and attack plaintiff's credibility. Defendant's flurry of texts with Mr. Sunstar Peterson's reflect just that. Okay. 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 Defendant attended every day of Mr. Peterson's criminal trial and sat with Mr. Peterson's family in the courtroom gallery, not with the media. Okay. Okay. Even after Mr. Peterson sat in prison as a convicted felon for shooting plaintiff, defendant not only maintained contact with him, but crossed a line no disinterested reporter would. She flirted with Mr. Peterson, her purported information source, instead of discussing legal strategies, alleged new evidence, investigative facts related to Mr. Peterson's appeal, or even Mr. Peterson's music career, or any other news. Defendant and Mr. Peterson shared love notes, complimented one another's looks, and expressed mutual adoration. Okay, y'all see? Okay. Defendant promotes her personal brand with biased, partial commentary favorable to Mr. Peterson. Defendant built her mob radio brand off of defaming plaintiff. Okay. Defendant's obsessive coverage of plaintiff, particularly concerning plaintiff's private affairs, such as her family background, alleged mental capacity, or alcohol consumption, undercuts her argument that she operated for the purpose of informing the public on matters of public concern. Rather, defendant built a social media business centered around smearing plaintiff's reputation. Defendant conceded she is not a journalist. Defendant repeatedly admitted throughout the trial that she has never been a journalist. She disclaimed any affiliation with traditional journalists or reporters and admitted that she never looked into the ethics required of journalists. And we're going to get into the statements from her live stream here. At what point in time haven't I told you to go do your own independent research? At what point in time hasn't this show read that this is for entertainment purposes? At what point in time did you really think that I was getting up here and I told you I have a psychology and criminal justice degree? I ain't never told you I went to school for journalism. What effing article did I write that I posted and said, y'all read this? What the F are y'all talking about? I don't think I'm anything, but I know I'm the person that gets under your skin. You don't need to be a journalist to see something and give an opinion about it. So, my whole thing is if I'm not trying to be a journalist and you know I'm not, what the F you mad about? Because I shouldn't be regarded as a news source any D word way. Okay. Defendant instead characterizes herself as more of an entertainer. Did y'all see that there? Okay. Okay. Defendant disseminates false and defamatory messages intended to misinform the public. There is no dispute that defendant is a prolific content creator. The evidence at trial demonstrated that defendant's content about plaintiff, which constituted the core of her online discussions, were false, biased, and defamatory. And you can refer back to docket 226. Defendant, no matter how regularly she released content, did not report on news or information related to matters of public concern. Instead, she was spreading rumors, speculation, and lies favoring Mr. Peterson and designed to obstruct justice in an effort to falsely exonerate him at the expense of plaintiff's reputation and emotional state. Okay. Okay. Let's get into the procedural background. The only time defendant raised the media defendant issue prior to trial was at the pleading stage in her motion to dismiss, and that is docket 30. The court disagreed with defendant and denied her motion on the ground, and you can refer back to docket 36. The court, relying on the well-pled facts, found that defendant lacked media status because she, one, is a longtime mouthpiece for Daystar Peterson, plaintiff's assaulter, and his father, Sunstar. Two, worked in concert with the Petersons to harass and discredit plaintiff on the Petersons' behalf. And three, publicly admitted that she is not a journalist. Defendant never moved for reconsideration of the court's ruling, nor did defendant move for a summary judgment at all, yet alone on the basis that she was a media defendant who would be entitled to pre-suit notice. At the October the 30th of 2025 pretrial conference, defendant again chose not to raise the media defendant issue, and you can refer back to docket 172. It was only at the final pretrial conference on November the 10th of 2025, after the close of proceedings, discovery, summary judgment, and prior pretrial conferences, that defendant re-raised the media defendant issue and requested leave to brief the issue on whether plaintiff was required to prove actual damages on her defamation claim. On the first day of trial, after the jury was seated and before opening statements commenced, the court again agreed with the plaintiff that the defendant does not qualify as a media defendant and found consistent with my ruling in my order on the motion to dismiss. The defendant is not a media defendant. Unlike at the pleading stage, the court based its ruling with the full benefit of the evidentiary record. It considered defendant's own statements made during her depositions, as well as her live streams, disclaiming any characterization as a journalist. And you can refer to docket 183. Nonetheless, on the fifth day of trial, after defendant had testified, her counsel again sought to re-inject the twice rejected media defendant issue. After the party submitted briefing and met and conferred, the court held that the issue would be submitted to the jury, subject to post-verdict briefing. And y'all can see the actual docket 183, 207, 208, 211. Plaintiff then sought to preserve and raise the issue after the defendant's case in chief pursuant to Fed RCF P50. The court advised that plaintiff could reserve on the motion. Later that day, at the final charging conference, when jury instructions were being finalized, the court determined that the effects of the defendant's purported media defendant status were not for the jury to decide. Okay. All right. On November the 26th of 2025, the jury began deliberations. On December the 1st, the jury rendered a unanimous verdict that plaintiffs favor on all three of her claims: defamation per se, intentional infliction of emotional distress, and promotion of an altered sexual depiction. Specifically, with regard to plaintiff defamation per se claim, the jury found that one, defendant defamed plaintiff, and two, such defamation caused plaintiff actual damages. And you can refer back to docket 226 questions 1 and 2. The jury also found that defendant did not provide disinterested and neutral commentary rather than advocacy for the particular client or personal interest, and did not impartially disseminate information, but rather acted primarily to promote her own business, provide disinterested, neutral, or impartial commentary, and used her platform for her own business interests. The jury determined that defendant qualified as a media defendant. Throughout deliberations, the jury had expressed confusion as to how to properly evaluate the media defendant factors. And you can refer back to docket 237. Okay. And that's all still the little case law there. Little quotes from the actual trial. Okay, so let's go right here to memorandum of law. Now, there are going to be a few things I'm going to read, and then again, pause your screen. You can read the other parts, and then we're going to continue. All right. All right. Now, I will have, as I'm saying, pause the screen, I will have this actual court document in the description box below. All right. So I'll do that as well. The MTD, which MTD stands for motion to dismiss order, decided that the controlling legal issue and became the law of the case for trial in post-trial proceedings. Okay, y'all can see that there. Again, I will have this in the description box below. Defendant waived and forfeited any attempt to re-inject the statutory notice issued at trial and is inadequately stopped from using it post verdict. Okay. Even part of the law of the case, defendants attempt to resurrect the statutory pre-suit notice issue after litigation and losing it on the motion to dismiss, declining to seek reconsideration or interlocutory. Oh, I mispronounced that word. All right, y'all, my bad. Interlocutory. That's how you say that word. Review, and then trying the case on the merits was waived, forfeited, and barred by fundamental fairness. Plaintiff reasonably relied on the court's MTD order and defendant's silence in shaping discovery, trial preparation, and the presentation of evidence. Defendant never preserved this issue in the joint pretrial statement and never raised it at the October the 30th of 2025 pre-trial conference, only to spring it on the plaintiff at the final November the 10th of 2025 pre-trial conference in trial as an end run around the jury's ultimate decision in favor on plaintiffs on her defamation claim. Florida's equitable estoppel doctrine exists to prevent exactly this sort of sandbagging. A party may not lull its opponent into a strategic and legal posture and then take an inconsistent position that inflicts substantial prejudice. And that's case law there. Okay. The media defendant special interrogatory was improper. A special interrogatory cannot be used to override the court's controlling legal determinations. Okay. Okay. A lot of case law there. But this look, we're on page 14 of page 20, and that looks like a lot of case law. Y'all can pause your screen. Again, it will be in the description box below. Okay, let's get into this one. Number 5, defendant is not a media defendant. The jury found that the defendant, despite advocating for a particular client or personal interest in acting primarily to promote her own business, products, or services, should be treated as a media defendant. And you can refer back to docket 226 at 2 and 3. But no court has ever extended media defendant status to a defendant who supplies and receives information to affect criminal proceedings, while maintaining a paid and intimate relationship with the accused. The court should not be the first. Florida's pre-suit notice statute applies to members of the media that seek to inform and initiate uninhibited, robust, and wide open debate on public issues. Okay. Courts have consistently refused to extend media defendant status to parties who disseminate information on behalf of clients or for personal financial gain. The court held that a public relations firm registered as an agent of a foreign bank did not qualify as a media defendant despite having sent press releases to major South Florida media outlets. As the court found in this case, false, intentionally misleading, or defamatory publications have no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. And that is a case law quote there from Ortega Trujillo. Okay. Okay, y'all see? All right, so let's read this right here. It says defendant statements clearly do not benefit order or morality. In fact, the jury found inevitably that the statements were defamatory, thus outside the ambit of protected speech under the First Amendment. You can refer back to docket 226 questions 1 and 2. Defendants' defamatory statements not only came at the great expense of plaintiffs' emotional well-being and professional and personal relationships, but also by their very defamatory nature caused harm to the public. Y'all see? All right, let's continue. The deleterious impact of her words is all the more evident here, where defendant statements sought to intimidate a key witness and crime victim and obstructed criminal legal proceedings. Likewise, defendant's use of disclaimers to inform her viewers that she should not be relied on for fact reporting cuts against her receiving media defendant protections. Okay. Okay. Defendant falls squarely within the category of non-media defendants identified in Ortega Trujillo and Tectronic financially motivated advocacy. Like the public relations firm in Ortega Trujillo, that was commissioned by its client to disseminate information, defendant admitted she was paid by Mr. Peterson's father, receiving $3,000 over 17 months for promotion services, and sought exclusive interviews that would change her life. Y'all see? Like Bonilla and Tectronic, defendant's own words condemn her claim to media status. She stated definitively and contemporaneously, I don't misbutcher that word, contemporaneously, that her commentary is not meant to be a news report, and I shouldn't be regarded as a news source any D-word way. Defendant supplied information to the Petersons in an effort to show that Daystar Peterson was innocent, then published information she received from them without any independent corroboration in order to sway public sentiment. Okay. Y'all see? All right. The jury's verdict confirms that they believe defendant acted on behalf of Mr. Peterson despite her testimony to the contrary. The jury was instructed that Ms. Pete claims that Ms. Cooper acted extremely and outrageously by coordinating with Mr. Daystar Peterson and others to distribute false statements about Ms. Pete and to promote and distribute an altered sexual depiction of Ms. Pete, which caused her severe emotional distress. Now, you can refer back to Docket 224 at 7. The court similarly instructed the jury that plaintiff sought punitive damages for conduct arising out of that coordination. The jury's verdict in favor of plaintiff on all counts and its award of punitive damages is unmistakably a factual finding by the jury of coordination between defendant and Mr. Peterson. And you can refer back to Docket 226. And not just any coordination, but the kind that is so extreme and outrageous that it goes beyond all possible bounds of decency. And it's utterly intolerable in a civilized community. And you can refer back to Docket 224 at 7. As the record reflects, defendant's so-called reporting was nothing more than the public relations arm of the Petersons. Her near singular focus was falsely discrediting plaintiff to advance Mr. Peterson's standing in and out of court. And when defendant was not acting as Mr. Peterson's mouthpiece, she was, as the jury found, inflicting intentional emotional distress and promoting a deep fake pornographic video of plaintiff. And you can refer back to Docket 226. Defendant's conduct is so far afield of what constitutes a media defendant that no court has ever granted media defendant status in these circumstances. This court has already ruled twice that defendant is not a media defendant under 770.01, and that's the Florida statute. And it should do so again now. And that is pretty much the bottom of the page. We're at page 17, and it says relief under Rule 59E. And Rule 60B6 is appropriate. Should the court disagree that the jury's verdict on defendant's media defendant status was advisory, such that the December 2nd, 2025 final judgment 227 was also a final judgment on count 1, defamation per se. Plaintiffs request relief from the final judgment under Fed RSF P60B6, allowing relief from a final judgment or order for any other reason that justifies relief, and Rule 59E, allowing motion to alter or amend a judgment. The circumstances here are extraordinary. The final judgment rests on a manifest legal error and results in manifest injustice. Not only did the court's final judgment revisit and reconsider the same legal question it had already decided in the MTD order, but it also relied on and permitted the jury to resolve legal classifications and standards reserved to the court. This appears to be the first case of its kind in which a jury decided, as a matter of fact, the defendant's qualification as a media defendant. The consequences are substantive, not merely technical. This combination of legal error and outcome determinative effect is exactly what Rules 59E and 60B6 are designed to correct and prevent manifest injustice. As such, the court should alter or amend the judgment to reinstate the jury's verdict and enter final judgment consistent with that verdict. And this is the conclusion. Wherefore, plaintiff respectfully requests that the court disregard or strike the media defendant interrogatory answers as immaterial. Enter final judgment in plaintiff's favor on count 1, defamation per se, consistent with the jury's verdict, finding defendant liable, and enter such other relief the court deems just as proper. And we are at the bottom of the page. How about that, y'all? Now, if you like what you've seen here today, like, share, and subscribe. I appreciate all of y'all. I love y'all. I couldn't do this without you. And until next time, and y'all know, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I will see y'all on the next video. Take care.